Well, that was the first case, Jews for Jesus, and I had never been inside the Supreme Court of the United States until 3 weeks before I argued that case. I was at a board meeting at Jews for Jesus. I was on the board at the time, and the executive director said, "We've got a case." The Supreme Court had just granted review. It was about literature distribution at airports, evangelism at airports. The Ninth Circuit had allowed the evangelism to take place, but the Supreme Court had accepted the case for review, and the thought was that they were going to reverse and not allow evangelism to take place.
The case is called Board of Airport Commissioners of Los Angeles versus Jews for Jesus. That case has affected every airport in the United States, opening them to personal evangelism and literature distribution.
I looked at all the cases involving religious distribution of literature and what's called the free exercise clause of the Constitution and how it applied to religious evangelism, and basically our side lost every single time. So maybe it was just me being naive in this sense. I said, you know, that area of law is not worked out very well, this whole free exercise issue. Let's approach this a different way. If this was a union organizer wanting to distribute literature at the airport for union organization, would the Supreme Court of the United States say, no, you can't do that? Of course not. Of course they would allow it. Well, then why would it be different if it was religious speech? And then I came up with this idea of let's argue these cases as speech cases, not simply a free exercise case. So when I went to the Supreme Court of the United States, my entire pitch in that case was this case is about freedom of speech. And I barely mentioned religion in the entire oral argument. 9 justices of the Supreme Court, the most conservative and the most liberal, agreed that that resolution for the city of Los Angeles, which said no First Amendment activities at the Los Angeles International Airport, all 9 justices agreed that, in fact, that was unconstitutional. So it was a huge win for religious free speech, probably the most significant win that we'd seen in 50 years.